Good morning, Counsel.
Good morning, Your Honor.
How can I help you today, Counsel?
May it please the Court, Your Honor, I am Meiqi Woo for the defendant, Duncan Moore, and my learned friend here is for the prosecution. I believe Your Honor has a copy of the submission I tendered before the Court.
Yes.
We are here on behalf of the defendant's application of adducing bad character evidence of a kitchen knife being found in David Parker's possession on June 1996. The previous law for bad character was that any other evidence of a person's crime or a tendency to commit crimes is generally inadmissible. However, the Criminal Justice Act provides for the admissibility of convictions in support of a propensity to commit like offences and untruthfulness.
So, Counsel, can you pause for a little while? So, can you just repeat which piece of the evidence of the witness, Mr. David Parker, that you wish to adduce in court?
I would like to adduce the evidence of a kitchen knife, a 3-inch blade being found in David Parker's locker when a search was conducted within the school compounds on June 1996.
Alright, so which means your counsel now would like to adduce that piece of evidence as the bad practice of Mr. David Parker?
Yes, Your Honor.
Okay, thank you. You may proceed, counsel.
So I shall proceed with explaining that Section 98 of the Criminal Justice Act provides the definition for bad character. For it to be fulfilled, it must not have to do with the alleged facts of the offence, and it also must show evidence of misconduct. The first criterion is fulfilled by the case R and Machado, reported in the All England Law Reports. Would Your Honour like me to like a brief summary of the facts of the case?
No, thank you, counsel.
So I shall proceed with the judgment. Lord Justice Thomas at paragraph 13 stated that all matters in this case were in fact contemporaneous and not closely associated with the alleged facts of the offence, and therefore not evidence of bad character. In this case, David Parker's possession of a kitchen knife with a 3-inch blade on school in June 1996 was a completely different matter and not contemporaneous on the day of the murder on 12 September 2006. And under the second criteria of misconduct, Section 98 is further elaborated by Section 112 of the Criminal Justice Act 2003, which describes misconduct as the commission of an offence or other reprehensible conduct. The case representing reprehensible conduct is demonstrated by R and Renda, reported in the first volume of the Westlaw Report. Would Your Honour like a brief summary of the facts of this case?
No need, counsel. But do you mind to explain to me that, as you mentioned earlier, the counsel would like to adduce the bad character of Mr. David Parker as the bad practice, right?
Yes.
So can you just explain to me what of his actions amount to bad character?
Actually, that was what I was going to explain further, Your Honour, with the case R and Renda.
Okay.
Okay, so in this case, Sir Igor Judge at paragraph 15 stated that reprehensible carries an element of culpability or blameworthiness. I want to emphasize to the court that David Parker's case, bringing a knife to school, is considered violent behaviour and should be qualified as reprehensible conduct. He probably brought the knife to school to cause harm, although he might have said in trial that it was actually for protection against bullying. No ordinary student would have brought a knife to school to retaliate bullying, and therefore that's why this is considered bad character on David Parker's part.
Alright. So, Counsel, can you just direct me that any statutory provisions that govern this area of the law about the bad character, please?
That is under Section 100 of the Criminal Justice Act.
Okay. Do you mind to repeat to me, please?
Evidence of bad character of non-defendants is admissible only under one of the three gateways.
Okay. So can you just pinpoint to me what are the three gateways, please?
Okay, it must be either important explanatory evidence, 2, it must be of substantial probative value, and 3, it must be agreed by all parties to be admissible in court.
Alright. So now, Counsel, which gateways that you are trying to submit?
I would like to highlight two of the gateways that I've mentioned, which is important explanatory evidence and substantial probative value. May I go on to explain what?
Yes, can you guide me through each of the argument, please?
Okay. Thank you, Your Honor. Firstly, Section 100, subsection 2, further elaborates that evidence is important explanatory evidence if it is impossible or difficult to properly understand other evidence in our case, and secondly, its value for understanding the case as a whole is substantial. The case in point would be R and Demore McIntosh, reported in England and Wales Court of Appeal Criminal Division. Would Your Honor like me to briefly discuss the facts of the case?
No, thank you.
Okay. The judgment is that Lord Justice Gage at paragraph 28 accepted that evidence of the defendant's possession of a gun is, if treated as bad character evidence, a bad character would be admissible as important explanatory evidence to explain why the rape complainant did not complain immediately because she was in fear. David Parker's possession of the kitchen knife on school grounds and the subsequent suggestion of the defense counsel that he actually had a knife in his denim jacket's pocket on the day of the murder when he left straight from school with Duncan Moore and subsequently played truant, it is important in explaining the conduct of the non-defendant David Parker.
Then can you tell me why this piece of evidence is so important to the court or the jury?
Because the flow of the event that in 1996 he had brought a knife to school for his protection, but later on in 2006 he was also suggested by the defense counsel that he had possessed a knife in his denim jacket's pocket is displays the conduct of David Parker that he was always in possession of a kitchen knife with him, and therefore it goes to show that he possesses bad character.
Okay, counsel, you may proceed further.
Secondly, I would like to go on to substantial probative value. Section 100, subsection 3 identifies factors to demonstrate substantive probative value. This encompasses, it's a long list of statutes, but it basically encompasses matters such as the nature, the gravity and the extent of any crimes, previous offences or misconduct. A significant case to demonstrate this is R and S Andrew in the England and Wales Court of Appeal Criminal Division. Would Your Honour like a brief summary of the facts of this case?
No, thank you. But you just highlight to me what is the relevancy of this case to the current facts, please.
The most significant judgment that was given by Lord Justice Laws at paragraph 15. And he mentioned that the complainant's persistent criminal record or dishonesty possesses substantial probative value. So in our case, Miss Murray, the head of English in school, had conducted a search and found a kitchen knife in David Parker's possession in the locker, and he had denied that he had brought it to school and said that it was actually planted in his locker by someone else. Further, on the day of the murder, he had deliberately left out his denim jacket and denied it to the police, and that was a critical piece of evidence, for it was suggested by the defense counsel that it was blood-stained, and that is precisely why his mother had washed it at 11:30 p.m. that night. Based on these two incidences, David Parker is his credit worthiness is questioned, since he had behaved so dishonestly on these two incidences which were related.
So what is the probative value to the case then?
The probative value is that without knowing that he had previously brought a knife to school, the jury would find it very hard to know that he had this propensity to bring a kitchen knife around with him.
Okay, you may proceed, counsel.
Furthermore, one of the leading judgments on substantive probative value is the case of R.M. Brewster, reported in the England and Wales Court of Appeal Criminal Division. Would Your Honour like me to give a brief summary of the case?
No, thank you.
Okay, it's important to note that the Court of Appeal laid out